Monsieur le Sénateur Rissier.
Présent.
Monsieur le Sénateur Osif. Monsieur le Sénateur McLean. Monsieur le Sénateur Gorst. Monsieur le Sénateur Farnham. Monsieur le Sénateur Balash. Monsieur le Sénateur Green. Madame le Sénateur Ferguson.
Présent.
Monsieur le Connétable de Saint-Hélier.
Présent.
Monsieur le Connétable de Saint-Clément.
Présent.
Monsieur le Connétable de Saint-Pierre.
Présent.
Madame le Connétable de Saint-Laurent.
Présente.
Madame le Connétable de Sainte-Marie.
Présente.
Monsieur le Connétable de Saint-Won.
Présent.
Monsieur le Connétable de Saint-Brelade. Monsieur le Connétable de Saint-Martin.
Présent.
Madame le Connétable de Saint-Sever. Monsieur le Connétable de Gruville.
Présent.
Monsieur le Connétable de Saint-Jean.
Présent.
Monsieur le Connétable de la Trinité.
Présent.
Madame le Deputy Martin.
Présente.
Monsieur le Deputy Southern. Madame le Deputy de Gruville.
Présente.
Madame le Deputy Hilton.
Présente.
Monsieur le Deputy Lefondre.
Présent.
Madame le Deputy de la Trinité.
Présente.
Monsieur le Deputy Louis de Saint-Sever.
Présent.
Monsieur le Deputy Tadier. Monsieur le Deputy Noel.
Présent.
Madame le Deputy de Saint-Jean. Monsieur le Deputy Higgins.
Présent.
Monsieur le Deputy Masson.
Présent.
Madame le Deputy Pinnell.
Présente.
Monsieur le Deputy de Saint-Martin.
Présent.
Monsieur le Deputy Bryans.
Présent.
Madame le Deputy de Saint-Pierre. Monsieur le Deputy Rondell. Monsieur le Deputy Mezek. Monsieur le Deputy Louis de Saint-Hélier.
Présent.
Monsieur le Deputy de Saint-Won.
Présent.
Madame le Deputy Dublé. Monsieur le Deputy Labby.
Présent.
Monsieur le Deputy Wickenden.
Présent.
Monsieur le Deputy Bree.
Présent.
Monsieur le Deputy Norton. Monsieur le Deputy MacDonald.
Présent.
Monsieur le Deputy de Sainte-Marie.
Présent.
Monsieur le Deputy Truscott.
Présent.
Monsieur le Deputy McClinton.
Monsieur le doyen.
Prions Dieu, notre aide soit au nom de Dieu qui a fait les cieux et la terre. Amen. Seigneur Dieu, Père éternel et tout-puissant, qui a établi les gouvernements et les puissances de la terre pour le règlement et pour la conduite du peuple, et qui nous a commandé d'avoir toujours pour vous la gloire de ton saint nom. Nous te prions qu'il te plaise de donner à cette assemblée le don de conseil et de prudence, d'unir les cœurs et les affections de tous ceux qui la composent, et de les conduire tellement toi-même par ton Saint-Esprit, que toutes les délibérations étant accompagnées de ta bénédiction, réussissent au bien et au soulagement du peuple qu'il t'a plu de commettre à leurs soins. Car nous t'en prions au nom et par le mérite de ton Fils bien-aimé, Jésus-Christ, notre Seigneur, qui nous a enseigné de t'invoquer en disant: Notre Père, qui es aux cieux, ton nom soit sanctifié, ton règne vienne, ta volonté soit faite en la terre comme au ciel. Donne-nous aujourd'hui notre pain quotidien, et nous pardonne nos offenses, comme nous pardonnons à ceux qui nous ont offensés. Et ne nous induis point en tentation, mais délivre-nous du mal, car à toi est la reine, la puissance et la gloire, au siècle des siècles. Amen.
Monsieur le Sénateur Osif.
Présent.
Monsieur le Sénateur McLean.
Présent.
Monsieur le Sénateur Gorst.
Présent.
Monsieur le Sénateur Farnham.
Défaut.
Monsieur le Sénateur Balash.
Défaut.
Monsieur le Sénateur Green.
Présent.
Monsieur le Connétable de Saint-Brelade. Je jure que Monsieur le Connétable de Saint-Brelade est tellement indisposé qu'il ne peut pas assister à ta son exposer sa santé. Madame le Connétable de Saint-Sever. Je jure que Madame le Connétable de Saint-Sever est tellement indisposée qu'elle ne peut pas assister à ta son exposer sa santé. Monsieur le Deputy Southern.
Présent.
Monsieur le Deputy Tadier.
Présent.
Madame la Deputy de Saint-Pierre.
Sir, could Madame la Deputy of Saint-Pierre be defer excusée, please? She's on State's business.
She's on state business.
Monsieur le Député Rondel. Je retire Monsieur le Député Rondel est tellement indisposé qu'il ne peut pas assister au tas sans exposer sa santé. Monsieur le Député Mesnick. Madame la Deputy Dublé.
Sir, can I ask that Deputy Dublay's defer excusée for family reasons?
Excusez.
Monsieur le Député Norton.
Les états sont constitués. We adjourned last night in order that the Minister of Treasury and Resources might provide members with some figures as requested. He has done so. I'm grateful to him. The figures should be on members' desks. There's nothing you want to add, Minister, is there?
Sir, I would like to just briefly add something, if I may, sir. I'd like to, first of all, apologise to members for the uncertainty created yesterday with the inability to confirm the figures. So the reason for that is that these figures are based on Q3 estimates. Estimates are permitted within the law for this purpose. And since the estimate was given in Q3 at the time of lodging of this proposition, there have been a number of updates on the figures. I was seeking clarification of what the latest updated figure was as opposed to the figure used in Q3. But what I can say to members is that the figures before them, which were provided this morning, are the position which demonstrates that the states would be compliant with the law in terms of approving this proposition, the borrowing up to 400 million. There are many other considerations I know members have got, but with regard to this particular issue, we are compliant with the Public Finances Law, and these figures demonstrate that point. Thank you, sir.
Point of clarification, sir. Just looking at the figures, it mentions various guarantees and everything else. I can see no reference to the depositor compensation scheme, which, if a bank fails, the first call for paying depositors is taken from the state's reserve. Surely those figures should be included in the figures we have here. Is that not correct?
It's not borrowing, sir, so the advice that we have is that it wouldn't be included in the figures that are before members at the moment.
Thank you, sir. Can I ask some questions of the Attorney General?
Well, I'm going to come to the Solicitor General for some advice in a moment. This questions for the Treasury Minister on the figures he's produced.
Yeah. Well, could the Treasury Minister then explain, because he's got the chance to, luckily, why, again, the long-term care charge is in? Because to me, you can only borrow against things that are literally you can spend. I and every other member in this House who passed a long-term care charge, sir, knows it goes to a ring-fence fund. So it is collected through tax, but it's not there to spend. So it shouldn't be. You take that off, sir, you're very close to that magic figure. In fact, you could be breaking it.
Well,
very concerned, sir. And the Minister needs to explain this to us.
Deputy, I think perhaps we hear from the Solicitor General first, because I think it's a question of law that has been raised as to whether or not Article 21, paragraph 3 is engaged. If it's not engaged, then the question you've just put is a political question which doesn't arise out of this debate. Solicitor General, you were asked whether or not Article 21, paragraph 3 is infringed, and whether it's legitimate for the state to authorize.
Yes, sir. I've considered the matter overnight, and I've reviewed the Public Finances Law and the Long-Term Care Law. I've also had regard, sir, to English case law concerning tax and contributions. Those are obviously not Jersey cases, but in my respectful view, they would be highly persuasive to the Royal Court in considering this issue. So, sir, in terms of how legally a tax is viewed and defined, so in law there's a distinction between charges levied by a state, which are contributions, and those which are taxes. So the classic example of a contribution is social security, whereas the latter taxes comprise all compulsory charges and taxes. So the distinction between a tax and a contribution is a contribution is essentially one of personal entitlement, arising by virtue of having made contributions and being calculated with respect to the amount of the contributions. So a classic example is national insurance or social security contributions, which in law are not, in English law, are not taxes. So there is a case in England concerning Goldman Sachs, where it was held that social security contributions are not taxes. Whereas a tax is one where a person is required to pay by virtue of having done something or because the state's permission is required to do something, or simply because the person exists. So a tax, it might be said to be something which the citizen doesn't really get any rights in return, whereas a contribution is something where the payer accrues an entitlement. So it doesn't need to be the case that a person who pays the contribution necessarily becomes entitled in due course. So other factors may affect that entitlement, such as where the individual lives in the future. But the causal link between the contribution and the entitlement must have some degree of reality. So here, indirect taxes, such as the IMPO, stamp duty, land transaction taxes, are taxes for the purposes of Article 21 of the Public Finances Law. And so in my submission, that's made clear by the definition of taxes and taxation in Article 1 of the law. So tax includes a duty and taxation shall be interpreted accordingly. That's the definition of taxation in the law. So rates are also taxes because the legislation imposes an obligation to pay rates by virtue of land ownership or occupation. However, social security contributions are not taxation, so they're not included for the purposes of Article 21. However, so taxes that are levied for specific purposes are taxation, notwithstanding that there may be legal limits on their use. So all tax is levied for a purpose or range of purposes. That a particular tax is legally directed towards a single public purpose, so-called hypothecated taxes, does not make it any less the use of state power to levy taxation. The fact that it's a hypothecated tax still means it's taxation. So a person who makes no contributions will still be able to benefit from long-term care in this case. Whereas a person who makes large contributions to long-term care won't receive any additional entitlement under the long-term care law to benefits. In this case, sir, the long-term care fund is not separate from the states. It's not a fund like PECA's or the Teachers' Superannuation Fund, which are separate funds from the states. The long-term care fund is a fund that's managed by the minister, that's set aside for a particular purpose. So ultimately it's a means by which the states will be able to meet expenses currently met by tax going into the consolidated fund. So if the states were to stop paying someone out of tax paid to the consolidated fund, but it allocated tax into a ring-fence fund, has the states lost income? No. It's still meeting public purposes through taxation. So I repeat, sir, a hypothecated tax is still a tax, and the expenditure it meets is still public expenditure. So it changes nothing but appearances that the tax is being accumulated to meet future expenses, long-term care costs in this case. So for the purposes, sir, of Article 21(3), in my opinion, in legal terms, I view the long-term care contributions as a hypothecated tax. And I do see it, sir, as income of the states for the purposes of the limit that's in Article 21(3) of the law. And that's my advice.
So that's the advice from the Solicitor General that the prospective borrowing is lawful. Is there any question from the Solicitor?
Yes, sir.
Solicitor General? Deputy Secretary.
So can I just ask two very minor queries on the long-term care thing, and then I have a more fundamental query on the law itself. The two minor queries, which I'm sure I just wonder if the Solicitor General could just expand on given his last opinion, because the actual, and I think it's the income tax law, seems to distinguish between a tax and a long-term care contribution. That's its phraseology. So, for example, an employer should not be required to deduct brackets tax and a long-term care contribution and remit them. And I'm just curious, because he said obviously Social Security is not a tax, which I think we all agree with. And one of the examples he used was that people, for the long-term care charge, was that people who pay a large contribution will not get a commensurate increase in the benefit they're receiving, whereas people who don't contribute to long-term care could receive the benefit of it. And I was slightly curious because the analogy it sprung to mind, and I may not be perfect on this, hasten to add, it seems to me that on long-term care, it's similar. You pay a contribution based on your, you pay a large contribution in potentially at the higher end, but your benefit is capped. But I believe potentially on Social Security, you can pay a large contribution in, but your benefit is taxed because it's a maximum pension you're going to be paying out, you're going to be receiving. And potentially, I think somebody on income support who may not contribute in themselves to the scheme will receive contributions. Somebody pays contributions on their behalf, which is the states. Therefore, I was trying to work out the distinction in the two analogies. Can I stop there? I do have a more fundamental question to answer.
So I think that is quite a technical question. As I understand it, sir, and as I'm instructed, the fact that someone pays in quite large contributions doesn't mean that they're entitled to extra benefits in the form of long-term care. Whereas someone who pays in nothing to long-term care because they don't meet the measure at which long-term care contributions are levied is still entitled to benefits under the long-term care law. So I think that's important in terms of analysing whether the long-term care contributions are best viewed as a hypothecated tax for the purposes of this particular provision in the public finances law. In terms of sir, whether someone pays contributions on behalf of someone who's not able to make them, whether the Social Security Fund pays contributions, I regret, so I don't have that information to hand. I'm not aware whether someone who is not able to pay contributions themselves has the contributions paid on their behalf by the fund. It may be that those who are closer to the detail of that would be able to assist the Assembly.
So perhaps the Solicitor General would give way on that point.
There's in connection with Social Security contributions which are not being taken into account anyway, so I can't see that's relevant myself. But
So can I ask my more fundamental query, which is...
what's different? Your second question.
The second query, sir, is that it's the Article 21.3 talks about the states should not authorise any borrowing, and Part 2 is, talks about security of the loan. And in the law, I couldn't see any definition of loan or borrowing. And the reason I raise that, sir, is I've always understood, and if I can talk for 30 seconds, I'll inform the Solicitor General, that if it's not defined in the law, it then becomes what is commonly understood. And I have to say that's when the accountancy hat goes on, because definitions, all those sort of things can get technical. But certainly I looked up on the an Oxford English Dictionary, borrowing is to render oneself indebted for, a loan is a thing lent, especially a sum of money lent for a time. A loan is the act of giving money, property or other material goods to another party in exchange for future repayment of the principal amount, along with, and it can depend, but along with interest. And the reason I've mentioned that, sir, is what actually is a borrowing. And, for example, would it include things like finance leases, which are about £4 million. Is it an obligation or a debt? And I think I'll stop there, sir. There's a follow-up question depending on the Solicitor General's thoughts.
I couldn't actually catch all of the question, but in terms of the bits that I did catch, it's correct that borrowing and loan are not defined in the law, the public finances law. So therefore it follows that their definition is a matter ultimately for the court to decide. And looking at how English case law has viewed as borrowing or loan, then they are essentially determined in accordance with their ordinary natural meaning, and the court ultimately has to find what the ordinary natural meaning is, and that's maybe different from how accountants view borrowing and loan. So there are many accounting practices and conventions, such as GAAP or GARP, as to how accountants view borrowings and loans. But those might be quite different from how a court would find borrowing and loan would be for the purposes of Article 21.3 of the law.
Sorry, so the definitions I read were actually not accounting definitions. One was from the Oxford English Dictionary. The reason I mention that, sir, is if it was an obligation or a debt. We have a thing called the pre-87 debt, which is pensions, which is approximately £300 million, sir.
So I'm not familiar with this pension debt. I would need to have further information about it, sir, before I could advise.
So perhaps I could help if the Solicitor General would
It describes the debt as understood as a deficit or a theoretical deficit on the pension scheme.
No, sir.
Is that what you're referring to?
No, so the pre-87 debt is an obligation to pay by the states over a period of time for what's called pre-existing liabilities prior to 1987 under an agreement reached with the pensions of the trustees of the day. And the amount is approximately 300 million.
These are legal questions for the Solicitor General. He's not able to answer that particular one. Deputy Sutherland.
If I may, sir, to give the SG a little break, return to the Treasury and Resources Minister.
No, forgive me, I really want to finish with the Solicitor General first.
I'll wait.
Then he can answer that. Nothing for you, Deputy. Chief Minister, did you have a question for the Solicitor General? Senator Rose, you did.
Sir, I know that it is not the practice of the Law Officers Department to say otherwise about legal advice being taken. But could I just, with the Solicitor General, inform the Assembly whether or not the Law Officers Department were consulted in any way prior to the Treasury Minister or his officials working out exactly what they were to be doing way back before even this proposition was before the Assembly, because obviously it's incumbent upon ministers to take advice. I know advice is never confirmed, but could I just ask delicately whether or not the Law Officers Department, with qualified advocates, was consulted and gave observations? Am I able to answer that, sir?
I don't know whether the Treasury Minister objects. I suspect he may not, but the Solicitor General, do you feel able to answer that question?
The Treasury Minister is shaking his head. So yes, in that case, then I can confirm that my department was asked for advice by the Treasury Department. That advice, the way it came in, sir, it didn't seem to be specifically in relation to borrowing for the hospital, which is why it wasn't on my file yesterday, or the Attorney General's file yesterday, which is why we've had to look at it overnight. But having looked at it overnight, yes, the Minister did receive some detailed advice from my department, and that advice did state in terms that long-term care contributions should be considered as income derived from taxation for the purposes of Article 21.3 of the Public Finances Law.
Yep.
May I raise the defo on Senator Farnham, please?
Agree, the defo is raised.
So thank you, sir. Seeing as we're in the unusual position where the client has waived his legal privilege for confidentiality with his legal advisor, in this case the Solicitor General, would the Solicitor General, with the permission of the Treasury Minister, say whether he was, or just confirm, was he specifically asked at any point by the Treasury Minister or officials for advice regarding Article 21.3 and whether it was a consideration for this debate before bringing it to the States?
So whilst I repeat that the advice didn't appear to be requested specifically in relation to borrowing for the hospital, yes, I do confirm that my department was specifically asked for advice in relation to Article 21.3. The request for advice was not specifically in relation to long-term care contributions. It was asked for slightly differently. It was asked for whether income from the state should be limited to certain classes of taxation, such as IMPO and stamp duty, and long-term care contributions was not specifically requested. But in the course of dealing with the request for advice, yes, my department did confirm that long-term care contributions did count as income of the states for the purposes of Article 21.3 of the law.
Final question. One question. Would the Solicitor General kindly confirm that there's, of course, it's not just one single piece of advice, that there were a number of files existing in the law offices as would be expected in dealing with the whole definition of what this law meant when the previous, for example, housing bond was taken. And so there is a general set of files which build upon advice over a period of time. It's not just one-off advice, because I just know I was there and I know the consultation that was made, and I could do all the mathematics in my head. But of course, that was when I was there. So it's just not a one-off issue, and law officers are always consulted appropriately. Were they consulted previously, so it wasn't just a one-off? Of course, I'm just trying to get to get the question that this is just not a nitpicking issue, that there is a general issue and good communication with the Treasury and law officers over a substantial period of time. Can you just confirm that that is the case?
Well, sir, I've only looked at one specific bit of advice, which is the advice that I've alluded to in my previous answers. I have no reason to doubt that there isn't other advice that's been given to the Treasury Minister, previous Treasury Ministers, in the way that Senator Ossoff has suggested. But I haven't seen further advice myself specifically.
So I have a follow-up question for the Solicitor General.
John, do you have a question for the Solicitor General?
Yes, thank you, sir. Can I ask the Solicitor General that from the information he's provided to us today, that long-term care charge is now classed as a taxation?
As I understood it, only for the purposes of paragraph Article 21.3.
Exactly, sir. My answer was limited to that paragraph, sir. So it is treated as income derived from taxation for the purposes of Article 21.3, and my advice goes no wider than that paragraph.
So I need to follow up. Oh, sorry.
Sorry, can I just seek some guidance from yourself, sir, with regards to that? Because how can it be defined purely for that paragraph and not for anything else?
The question which is before the Assembly is whether or not the current proposition is lawful in the sense that the states are able to authorise borrowing, and therefore it's necessary to look at that question by reference to Article 21, paragraph 3, which creates the restriction. And the advice which the Solicitor General has been giving the Assembly is limited to saying that in relation to the long-term care monies, they count as taxation for the purposes of Article 21, paragraph 3. That's his advice. And that really ought to be conclusive as far as this Assembly is concerned. But when we don't have legal debates in this Assembly, you've got the advice.
Sorry, sir, this will turn the debate or not, and I don't disagree with the Solicitor General, I wouldn't dare. But he did the Solicitor General say, sir, he had to look at English case law, and in England, this fund would be out, and it could be tested here. I think somebody will test it if it goes through today, because nobody was under the impression it was a borrowing against. Don't disagree but could I define that point, because I'm sure he said in English case law it wouldn't be in the pot to be borrowed against.
So I'm not sure I did say that, sir. I looked at English case law for guidance as to what was a tax and what was a contribution. My comments were limited to that. I was not saying that in England, if this question were to be considered by the House of Commons or by a court in England, that the contributions for long-term care would be excluded as income derived from taxation. My answer was not to that effect. I'm not sure that it's appropriate for me to be opining on English, what would be done in England or English law.
Deputy Bree, you had a question for the Treasury Minister, did you?
No, sir. It's actually a bit more fundamental than that. The discussion and seeking of advice on what is classified as income based on the sheet that was provided us today, I would raise the issue that there is a fundamental error in the sheet that has been provided to us, in so much as the unsecured housing bond has a nominal amount of 250 million. The obligations on any issuer in the bond market is to repay upon maturity the face value or nominal amount of the bond issued. The fact it was issued at a discount refers to the amount of money that was received by the issuer from that issue. The obligation on the issuer upon maturity in 2054 is to repay in full the face value of 250 million. That fact alone means that the balance borrowing limit after guarantees is less than 400 million. And therefore, sir, I would suggest that this information that has been provided to us is based on an incorrect premise. And I would seek advice, sir, on what we do now. Thank you, sir.
Thank you, Deputy. I think the first question which arises from that is one for the Treasury Minister, and that is why, Treasury Minister, in your figures, you have put an estimate, you have put a detail of the borrowing figure at less than the amount which, according to Deputy Bree, is the nominal amount which is forced to be repaid.
Yes, sir, that is correct. The advice we received, sir, that was correct. This figure is carried in the state's accounts at 243 million, as members will have noted. In fact, this is a result of the way in which the bond market functions and the quarter point differences in terms of issuance. So effectively, as the Deputy has quite rightly pointed out, £250 million was the figure sought, but in fact, that was at a strike rate of 3.84%. It was discounted to the nearest quarter, which was 2.75, which represents a discount over the term of the borrowing. And as such, although 250 million will ultimately be paid back, the advice we've received is carrying this amount in this way and showing it in this way is correct, sir. Because that's the amount we actually received. We didn't receive 250 million. We received the amount shown.
Excuse me, sir, if I may clarify the situation. As a qualified bond dealer through the International Securities Markets Association, there are two prime obligations on any issuer in the debt market. One is to repay the nominal value, face value, at par, which is 100% of the issuance amount. The second obligation is to meet the terms of the issue, which is to pay a set coupon or interest rate to investors in the bond. The bond market details the fact that the states of Jersey have an outstanding debt in the bond market of £250 million sterling. That is the amount that is required to be repaid upon maturity.
Deputy, I think actually we're only dealing with the question of law at the moment. I wonder if I can just put a question to the Solicitor General. For the purposes of Article 21, paragraph 3, are you able to say whether the word borrowing should include the nominal amount or the amount that was actually received?
So,
as an issue of this is a matter of construction law.
Yes, sir. So, as I understand it, it should be the amount that's actually received, because the other amount seems to me to be just a form of interest or deferred interest. So I would say, sir, it's the amount actually received.
Well, I suspect that we've got as far as we're going to get in terms of legal matters. Members will have to make up their minds in due course on what they think is the appropriate way to...
Sorry to only on the basis that the Solicitor General did elaborate slightly on the advice that was sought. May I ask whether the advice included consideration of what constituted borrowing?
So the previous advice that was given to the Minister, I think back last summer, I think it was, did not include specific consideration of whether it should be 243 million or 250 million.
No, but I think what you're being asked is what does the word borrowing mean for present purposes?
Well, for present purposes, I think it is the 243 million in terms of that.
I think it's wider. I think the Deputy's question is wider than that. The question is what sort of liabilities amount to a borrowing? Is that what you're asking?
If you can give that answer, but as actually was advice given to the Treasury Minister on what constituted borrowing?
Well,
so it's whichever way you want to phrase the question, sir.
This question arises at whether or not the states would be acting lawfully. And that is really a question of advice for the Solicitor General to give now. And in that context, it's important that he is able to say to us that the borrowing figures, which are shown on the information given to him by the Treasury, are appropriately referred to as borrowing. That's really amounts to it, doesn't it?
Yes, and as I asked earlier, would finance leases have been pulled into that and that type of idea?
Well, sir, I think in terms of finance leases, that was also specifically considered in the advice that was requested by the Treasury Minister, and there are distinctions between different types of finance lease. But as I understand it, the relevant finance leases in this case, which I've not seen, but it was considered in the previous advice, could be discounted for the purposes of this calculation in terms of Article 21.3 and the borrowing limit. But I repeat my earlier answer. Borrowing is not something that is defined in the law. It is something that would ultimately have to be found by a court. And in terms of the English case law, it gives its ordinary natural meaning. And leases, finance leases, it really depends on the terms of the finance lease. But as I understand it, the particular finance leases in this case can be discounted for the purposes of the calculation.
A legal question, please.
So yes, I just it's a point of clarification on the legal question.
It sounds like another speech.
No, it's not. It's not. It's to assist members because I know this article well. I think I brought it.
It does sound like a second speech. We're dealing with questions.
Yes, questions. It relates to the issue that Deputy Bree raised.
Well, what is your legal
question? The point is that a
what are your legal questions?
The question is the legal question is that. Would the Solicitor General also agree that there is an apples and orange comparison that case law also will be aware of, or is he aware of it, whereas actually the net present value of the borrowing, whilst today 250 million, we're comparing it with the estimates of income today, and just a discount rate of 2% would mean that that borrowing in 40 years' time would be actually 120 million. This is just people are putting sand up, sir, and the sand can be put up on both sides. And I'm confident, from what I've heard from the Solicitor General, who's been put under a very unfair situation, sir. I'm allowed to speak, if I may, aren't I? It's sand, and you can argue things both ways.
I think the answer is, Senator, no, you're not allowed to speak. You've spoken already. But the Solicitor General has given advice that on the figures which have been given to him, the borrowing is lawful. And that's the advice which the Assembly has. Members must make what they want.
Exactly so, and it's lawful, and as it would be. Advice is always taken, and it's lawful.
Chief Minister?
Sir, I thank you for your last intervention, because I just wanted the Solicitor General to reconfirm that, because all the questions that members have had here have been an ongoing dialogue between Treasury officials and the Solicitor General's department, and as the Minister said, there's lots of detail about that. But could the Solicitor General please, sir, for clarity, confirm, we may not have liked his advice, sir, about what was in and what was out, but could he confirm absolutely categorically that what is before the Assembly is lawful in his opinion?
My advice is that on the basis of the figures that are provided by the Treasury Minister, the amount of borrowing sought is lawful for the purposes of the calculation in 21(3) of the Public Finances Law.
Oh, that's right.
So could I thank the Solicitor General for his advice and the way he's handled those difficult questions today?
Thank you. Right, we now return to the debate. Deputy Southern, you wish to speak?
I wish to
You've
ask...
spoken already. You can't speak. You have a question then?
I have a question, clarification from the Treasury Minister, sir, if I may. And it is this, that Article 21(3) of the Public Finance Law refers to estimates. We are told that this is the latest estimate from quarter 3 last year, and that gives us a margin of £2.3 million to play with. The question is, what we are debating today is whether to refer this proposition to scrutiny, and that may well cause a delay. Is it the case that by, let's say, April of this year, we have time to do the end of year estimate on 2016, and is that and might that show a different figure? Will it be available come April?
Yes, sir, I can help the Deputy with that. These figures are based on estimates at quarter 3. What I can tell, which was the time clearly that we were lodging the proposition or preparing the proposition for lodging, I mentioned earlier on that there have been a number of updates since then, hence the confusion yesterday. What I can tell members is that the position has improved quite significantly, actually, in terms of our income. But that hasn't yet been finalised, but we can provide figures to members later on, which will show a significantly improved position with regard to our income, which ensures that this proposition is without doubt compliant.
So new figures will be available before, let's say, April?
New figures are, estimated figures are available now, which are significantly higher. But yes, indeed, there will be updated. The outcomes, the final audited outcomes from 2016 will be available in, by the end of February, March is the usual time.
Right, we're going to go back to the usual rules of order and resume the debate on the proposition to refer the matter to scrutiny. Does any other member wish to speak? If not...
Yes.
So, I'm sorry.
Thanks, sir. Well, it's been a busy couple of days, hasn't it? And if you're listening at home on the radio, I'm sure that the public will have their own opinions of what they've heard after the eventful day that we had on Tuesday, only to be topped by yesterday's what one might call shenanigans. It seems to me that if ever we needed something to be put before scrutiny. It is this. It was this already before we had the debate, and how much more after the debate and the ensuing confusion, the late figures that we've been given, the controversy over what counts as legitimate taxation and what doesn't, what should be put in, what shouldn't be. And then at the very last moment, of course, we have the Solicitor General quite helpfully confirming what most of us, I think all of us, already knew in our heart of hearts, is that the long-term health charge, note the LTC, not the LTT, is, lo and behold, actually a tax, which is something, as I've said, we've been saying all the time. Which means, presumably, that the Council of Ministers will have to issue a press release for the locals, because at the last election they were saying, no, it's not a tax, it's a charge. I'm sure the international community will also be interested in the fact that we no longer have a headline tax of 20%, but we have a headline tax of 21% going north as we go along. Who knows where it will end up, like GST. It's worth remembering, of course, that political assurances aren't always worth the paper that they are written on, because we know that GST was promised to stay at 3%. As soon as the person in charge of that got elected, it went up to 5%, and some of us have short memories, but I think the public and many of us have much longer memories than that. So at least one thing that's come out of this debate is that we know for sure now that we have a 21% headline tax rate in Jersey. Now, why is that relevant? Well, I think not just this, but it shows that the Council of Ministers actually have lost the confidence of the public, and they should be losing our confidence. I mean, not just the events of Tuesday, but certainly yesterday and today, and what's happened and the way this is rolled out. Anywhere else, it would be completely unsustainable for this government to even remain in office. There would be demands, if not from the Parliament, but from the public and the media, that they stand down immediately and hold a brand new election to see if they actually can form a new government. Now, we know we have a completely different setup in Jersey, but were it not for the fact that yesterday a very diligent backbencher in the Deputy of St John's stood up and said, hang on a minute, is Article 21(3) not a factor here? And then we have all this running around, and we had to be saved from what I perceived from the chair, who quite rightly made some correct decisions and said, actually, are we sure we're going in the right direction? Took an adjournment. So when I was at home, wasn't well yesterday, trying to get on the iPad, on the iPlayer, it says, oh, the session has been paused. Quite rightly, because some things, some answers, some information quite urgently needed to be provided. Now, does this mean that it should just be passed through on the nod, or does it mean that actually this should go to scrutiny? I heard the Chief Minister say yesterday that actually there are strong arguments for and against referring this to scrutiny, to be called in for scrutiny. For him to say that actually it's a marginal call shows that I don't think the arguments are on his side. And he talked about, well, actually the markets could go up, they could go down, the interest rates could go up, we could find ourselves paying more in the long run. We live in volatile times, but they could also go down, at which point you should be thinking, oh, well, we made the right decision. But it shouldn't be a toying cost. We're not financial clairvoyants here. We're politicians. We shouldn't be actually speculating on what the markets may or may not do. We should be observing political best practice. And the political best practice is to use the long-established processes that we have in this Assembly, the checks and balances, which is the formal scrutiny process. The Council of Ministers, quite frankly, should be biting the hand off scrutiny to look at this, saying that we've got these figures, we think it's important to work together. How often are we told that it's important to work together? Saying we think we got the figures right, but what do you think of them? A 6-week delay, it's not even 6 weeks, I don't think, is it? But a 6-week delay is not going to make the world of difference, but what it will do is ensure that we can actually make the right decisions. We can have the confidence not simply of what we're being told by the ministers, who obviously have their own political agenda, nothing wrong with that. The health minister wants to be seen after years of prevarication and getting it wrong about the site of the hospital, that actually now we're taking firm steps. But in the context of that, surely the right thing to do, no matter which side of this Assembly you are on, is to refer this to scrutiny so that the public, and equally as importantly, we as members can have full confidence on what we're voting for, which is the largest sum of money that Jersey has ever borrowed. People not only of my generation, but the generation to follow, who will be saddled potentially with that debt anyway, and even more so if something happens to go wrong. How can we look them in the eye and say, well, actually, we just took it on trust, irrespective of the fact that all these questions has come up, there was so much uncertainty, even at the last minute to pushing the button, but we just took a blind leap of faith. No, we don't do that. We use the processes that we have. If the interest rates go up, so be it. If they go down, the most likely, I imagine, is that there's no real change, but that's not really relevant for us. We must stick with the political processes that are in place. Please refer this to scrutiny, and this shouldn't be something which is ministers versus anyone else, as it was said. This is about doing the right thing. The right thing is to vote for this reference to scrutiny, surely.
Comments of St Mary.
Thank you, sir. I find myself in a position where I'm in agreement with so many things that the previous speaker has said, but I'm have fundamental problems with other things that he said in that one speech. So that's the only reason I've risen to speak, because I've got a sort of mantra that I've been banging on about for the last, I don't know, few months, definitely, perhaps longer, that we are not communicating what we do. And I'd just like to say that this just goes to the heart of it. To lay my cards on the table, absolutely without question, this must go to scrutiny. I completely agree that. But having said that, like many members, I think, here who were in that debate when we brought in the long-term care allowance, I sat through the debate. I heard an amendment brought by Deputy Young, at which time he said, basically, if it looks like a tax, it is a tax, whatever. Then I heard another member, who's also not here with us now, say, no, it's more like an insurance scheme. And that was picked up in the minister's summing up. All the way through that debate, the question of tax was bandied around. Now, where I differ from Deputy Tadier is, whilst he said we're not all financial, I don't know what the word he used, financial experts, we're certainly not, most of us, lawyers either. And the Solicitor General was quite specific. Often things have different meanings depending how they're construed within the law. We know that. The Solicitor General has tied in this meaning of taxation to a specific article, nothing broader. My own personal views on that are quite clear, but we are not talking about anything wider than that article at this moment. But I can be sure that if I don't do it, and I think I probably will, other members here will be asking for clarification of exactly how that charge sits in the taxation structure through the proper venue, whether that's questions or whatever, in probably the next sitting. I agree completely, obviously, with take the advice of the chair. That's not the debate we're having here, certainly. But what I have to say about this is, going back to the clarity, we cannot carry on. I don't know. It's not double speak. I'm sure it's not a deliberate leading away. But we can't use jargon. We can't do anything else than be crystal clear in what the meaning of what we're doing is. Because if this assembly, which has access to more information directly from the office, directly from the ministers than can ever have the general public, if we cannot be clear about what's being said and what has been said and where it sits, what hope is there for the public to have confidence in us? It took this has been, I think, in 11 years, I think I've been in the Assembly now, for lots of reasons, for the lack of clarity, for the lack of clear procedure, for the behaviour, I will say, of some members in various contexts, the least satisfactory sitting of the states that I have ever been party to. We have to do better. We must do better. It took, through all the toing and froing, all the difficulty, and I thank goodness that I'm not in the chair, that somebody inexperienced is not in the chair today, to have seen through this. It took a simple question, a straight question from the Chief Minister, can the Solicitor General assure us that this thing we are discussing now is legal? To have a straight answer, yes, it's legal. That cut through everything. It was a simple, direct question. I have such fear that we don't do that often enough. We're not playing a bluffing game here. We need to know exactly what we're doing. And I really feel that the Council of Ministers, again, I've said it a couple of times in recent debates where things have come to light at the last minute or interpretations have been opened up at the last minute. We're not doing ourselves any favours. We really are not. And the public must have the confidence that we understand what we're doing and that we're doing it for the right reasons. And I think there are much bigger questions to be answered by us now as an assembly than simply this matter. But this must go to scrutiny. There is no alternative now. The weight for that decision of will we gain, will we lose, is now firmly on the shoulders of the assembly. That's what our decision is, but that's what we do. We make decisions like this all the time. It's no big mystery. I'd like to tell the people of the island that this will go to scrutiny. Please don't make me wrong in that, because we have to get the confidence back. And there is a process to do it. We all share in that process, no matter which side we sit on. It's not scrutiny versus executive. It's the States Assembly for the people of the island. Remember that message. I've got a lot more to say about how close we almost came with the health charge, and would that have been another taxation for this purpose? We didn't go there. We wanted clarity on that. Let's carry on in that spirit of clarity. Let's put all this divisiveness behind us, because that's what we need to do. We need to lead this island. Now, if people say we haven't got the right people leading us, where are the people who could step up to the mark and do that job? Where are they? Let's get them in here. Because we have a duty now for the next year and a few months to lead this island, to take it forward and to do it, and to get the people of the island behind us. So please, just get on and do it, sir. And really, sir, I can't see why we need to debate this anymore. I think a very brave member of this assembly who's going to say this is fine, let's do it without scrutiny. Thank you, sir.
Anybody else member wish to speak? If not, then I call on the Deputy Assistant to reply.
Thank you, sir. It really seems an age since I stood here and proposed a reference to the scrutiny panel. It is an age. But I would first like to start by thanking all those who have contributed to the debate. It has been an extraordinary debate, but one that was needed. And some have described this as a contest between the Council of Ministers and scrutiny. But I would prefer to regard it, much as Constable St Mary has said, as a struggle that we've had to determine where the greater public interest lies and how we can give confidence to islanders that a sound decision can be reached in this matter, which is hugely important to the island. We're elected to be the decision makers, and I think it's clear from this last day that we've taken those duties seriously. And surely all that has happened yesterday and today shows how decision-making is improved and becomes a better informed process when questions are asked, when assumptions are challenged, and with a careful examination, an examination by others who stand at a distance from the original proposal and are separated from those who have worked day in, day out on a proposal. That is what scrutiny provides. That is what is needed. And I ask members, don't we do this in our daily lives? If we have an important decision to make, we may have worked out in our heads and have some feel for the way we think we might want to go, but don't we often seek out the advice of friends and family? Because we recognize as humans that a different perspective can sometimes provide that valuable insight, and that can change our minds, and that can alert us to dangers. And why should it be different in government? Because government is made up by those same incomplete, frail humans who don't always have the same picture. It's not different. Scrutiny, the critical friend. Heard that said. Now, why isn't that accepted? I believe the issues we've discussed yesterday and today would have come to light in a scrutiny examination. A panel and its advisor would have begun by looking at the authority quoted in the proposition, the authority to borrow funds, and the scope of that authority. But we weren't allowed to do that because the Council of Ministers was refusing for this issue to go to scrutiny. So instead, this Assembly had to start acting as the scrutiny panel. So we've begun the work of scrutiny. We've begun to ask those very technical, detailed questions which needed asking and which caused difficulty to our advisors sitting at the back there. Difficult questions asked on the hoof, which shouldn't be asked on the hoof, which deserve detailed consideration. But we've had to do it as Assembly members because we've been refused the alternative avenue, which is the right avenue. The sort of information we've been seeking should have been provided in the proposition. Clearly, the Council of Ministers, the Treasury Minister took advice. That advice was complex. We should have known how close we are to the margin. And we should have known that the calculation now includes the long-term care charge. Oops, it's a tax now. But we've been told all the time, no, it's not a tax. We don't include that in taxation. Our standard rate of taxation is 20%. No, it's not. Now we've got other elements of taxation for this purpose. And of course, the advice can only be for the purpose. But what are the ramifications of that? So there's the long-term care issue. There's the discounting which Deputy Bree has raised, which requires some expertise to understand. There is the question of the finance leases. There are all sorts of questions. There is the issue that the figure given here of total forecasted taxation is different from a figure that was given to the Education Scrutiny Panel just in November. And in a public hearing, there's that uncertainty. That transcript's not on the website yet, but I've seen a copy of it. And we're advised that ultimately all these questions of definitions are ultimately up to a court to decide. Such uncertainty. And yet we were not advised. We were told to take everything on trust. The Constable of St John is a member of the Corporate Services Scrutiny Panel. The issues covered by his amendment were seen at an early stage by the panel. And they were brought before us by way of an amendment from the Connotab because it appeared scrutiny were not going to be permitted to investigate and to report. Yesterday, the Chief Minister accepted the original proposition was ambiguous, and he thanked the Connotab for his amendments. Doesn't all that we've been through yesterday and today, doesn't the fact that the Connotab was compelled to bring his amendment to improve the proposition just show how much scrutiny has to offer in this process? And yet the Council of Ministers yesterday, throughout, and still now, is saying that there is no need for scrutiny, that we should trust. Well, that they don't wish scrutiny, that they don't agree that scrutiny should be permitted without arguing this matter in this Assembly. We have to fight. Isn't it ridiculous that members have to fight to have this matter scrutinised? Council of Ministers, please don't do this again. You have created such embarrassment. This has been an embarrassing day. The Assistant Treasury Minister, when he spoke yesterday, told us the options were well laid out in the proposition to give us confidence. He also said we can rest assured in the advice given by EY, the Treasury Advisory Panel, various other bodies. Senator Ossoff asked why we could not trust that advice. He told us that the Treasury knows what it is doing. But we've not seen that advice from EY or others. It's not here to contribute to this debate on funding. We can't interrogate it to satisfy ourselves as the decision makers that it is sound advice. Now, as Deputy Southern freely admitted yesterday, and I'm in the same position, not all of us are familiar with all these borrowing terms and processes. So I can't adequately test that advice. Who usually does that for us as Assembly members? That detailed examination on our behalves as decision makers? Well, it's a scrutiny panel. It's a panel that takes advice with assistance from experts in their field. And we know that is the way ministerial government was set up, to give members that assurance that there is an independent examination of ministerial proposals. And not just members, but to give islanders that assurance that what ministers want to do is tested out by their elected representatives. But instead, we're being asked to take it all on trust, that everything had been thoroughly researched within the Treasury, and the advice is comprehensive, clear, and incontrovertible. We are asked to be nodding dogs to do the bidding of the Council of Ministers. But as I said when I proposed this reference back, but I think it bears repeating, every minister could say about every proposition that comes forward that if their proposal is not immediately implemented, there will be undesirable consequences. They could be financial consequences. They could relate to manpower. They could delay the introduction of a service. But ministers usually accept, because this is the parliamentary procedure, that there's a process to undergo that involves scrutiny. Like it or lump it, ministers have to incur the consequences. And sometimes they come through the process and they say their proposals are all the better for going through scrutiny. Just sometimes. But it seems to me yesterday ministers were sending out the message, they are places where scrutiny cannot go. Where proposal, in the opinion of the Council of Ministers, has significant risks attached, this Assembly should approve it without delay, because the Council of Ministers have got it right. But I say, definitely not. Where proposal has significant risks attached, there is all the more reason to refer it to scrutiny for a detailed examination. And haven't we seen the necessity of that when we have been forced into beginning the work of scrutiny as an Assembly? We have seen how much comes out that hasn't been clear, that has yet to be thought through, that questions have still to be asked. The Council of Ministers would say that delay risks incurring cost. And it might do. But scrutiny is the safeguard. It is the quality assurance label for the members of the public to ensure that ministers' proposals are robust, they're properly planned, and they're the best possible solution for this island. Scrutiny is a process to highlight errors where greater cost might otherwise be incurred, or to suggest improvements where costs might be saved. And I ask members to bear in mind that ministers have lived with the volatility they so fear since 2012. It was in 2012 that there was a first shortlist of sites for the hospital. And 2012, that there was the beginning of the arguments over site selection. That hospital site selection process has been protracted over 4 years. The funding proposals have been under examination by Treasury since at least the Future Hospital Scrutiny Subpanel, which I chaired, was formed not last year, but in 2015. And I still don't understand why it has taken so long to bring these funding proposals when the only two viable options for the site selection were costed at broadly the same amount, and that information was known for many months before this proposition was lodged. And yet, the Corporate Services Scrutiny Panel asked for an additional 2 weeks to carry out its review, and that was refused. Suddenly, 2 weeks is a step too far. It is too great a risk, and there should be no delay. We've heard the forecasts. The Health Minister, if we delay, quite likely it would cost more. The Assistant Treasury Minister, who told us the situation can only get worse. Deputy Lewis, who told us that interest rates will rise. Yes, Deputy Lewis or St Helier? Okay. The briefing note that we were provided with on the 13th of January, a few days ago, speaks about advice. Most market commentators and strategists see a gradual grind higher in gilt yields. Those are the forecasts. They may or may not be right. The Treasury, the Council, the Chief Minister accepted that interest rates might also fall. There is uncertainty. There is volatility. But are these warnings about the risks warning us about a catastrophic cliff edge? A great disaster? No, these are the type of risks that are always with us. The type of risks that the Council of Ministers has been bearing for the last 4 years whilst it has had its discussions. Having carried that risk for so long, we need to decide now whether we can bear them for a few weeks more. And there is nothing I've read in the proposition, and nothing I've heard yesterday, and nothing I've heard today that tells me the situation has changed so fundamentally that we need to take this decision immediately. And we should abandon the normal scrutiny process. Nothing at all. Yesterday we were also told that total construction costs would increase if there was a delay. Now, it seems to me this is a total red herring. At this very moment, and for the rest of this year, a business case is being drafted for the hospital preferred site. Detailed designs are being worked up, and a planning application is being prepared. Nothing is going to move on site until summer of 2018, subject to planning consent, subject to further votes in this Assembly. Is it being seriously suggested that the Future Hospital project team are going to set down their pencils, their set squares, their slide rules, and their calculators, whilst Deputy Lafondre and his panel take a few weeks to prepare a report for us? But of course not. The work they're doing is continuing, is going to continue, and there's nothing about referring this question to scrutiny which will delay the hospital construction. And when that point was raised by more than one speaker, it became abundantly clear to me that there was much over-egging of that particular pudding. And it is still being suggested by some ministers that scrutiny is at fault for not searching out a draft proposition before it was formally lodged. Now, if ministers want to play that sort of blame game, then I would like to remind them that on the 7th of November, when the proposition was apparently discussed in the Council of Ministers, my future hospital sub-panel was still operating. We had not reported, and I would if members would give me a moment to fire up. To reboot. Remembering the Treasury Minister had given us a briefing in only the month previously, why didn't the Treasury Minister forward to my sub-panel a copy of his proposition? Especially bearing in mind the Code of Practice for Scrutiny Panels, which has been agreed by this Assembly, which says it is expected that written submissions from the Executive will be based on the formal request from the panel. However, it is beneficial to the overall process for the Executive to provide any additional relevant information, whether or not this is specifically requested, to ensure that all aspects of the topic are comprehensively covered. That proposition wasn't provided to my sub-panel. Isn't it the most significant proposition that we have debated for a long, long time? But it's ridiculous, really, to argue over whether scrutiny could or should have begun a review a few days before formal lodging. The fact of the matter is that the proposition seems to have been agreed in the Council of Ministers on the 7th of November, but only lodged on the 30th of November. I'm not sure what happened between and why it couldn't be lodged before, but here we are 6 weeks later with the responsibility of deciding upon it. Just 6 weeks. Now, I am certain, from only 2 years as a chair of a scrutiny panel, that it is just not possible to complete a review into an issue of this magnitude with the need to engage professional advisors in that 6-week period, let alone having Christmas and the New Year holidays intervening. I believe those of us who serve on scrutiny or have served on scrutiny will know that almost by instinct. And I find it very regrettable that ministers, many of whom have not served on scrutiny, fail to understand that and going further and casting blame on a panel for its failure to do so. If the ministers feel that the scrutiny process should be more fleet of foot, let's discuss it in a different context without casting aspersions. We would like to improve procedures in scrutiny, and believe it or not, we have some ideas to improve ministers also. Some have suggested that we can make the decision today, but scrutiny can still go away and do its work. Deputy Le Fondre has spoken to that, and I concur with what he's said. If we reject a reference back to scrutiny and decide to fund the hospital funding proposals today, this matter cannot come back to this Assembly for debate. Any findings and recommendation that Deputy Le Fondre's panel may come up with couldn't inform any sort of decision on this proposition. So what point? There's no point. It would be hard for us as scrutiny to justify the cost of advisors. Finally, I'm sure members would be pleased to hear, but I'm sure members need no reminding, but I want to emphasise the explanation of scrutiny's work which is given on the States Assembly website. It is this: scrutiny helps to improve the delivery of public services by ensuring that decisions are soundly based on evidence. And therefore, I maintain my proposition and I call for the appel. Thank you.
Mayor, point of clarification.
Senator Rossif.
Thank you, sir. I asked the Deputy in his summing up if he could clarify, because there's a number of questions I posed to him, and in the spirit of the wise words of the Constable of St Mary, I say this with the respect that communication is vital, and so I just would invite the Deputy, for the avoidance of doubt, if he could confirm the questions that I asked him, and that the matter is referring the whole proposition back, but that Part C...
So this is as I understand it, the proposition is to refer the entire proposition to scrutiny. Full stop.
I asked him specific questions about different parts of the proposition, which if he could convince me that there was a case for the whole of it, I would if I wouldn't.
But the proposition is to move the whole of this proposition to scrutiny under Standing Order 79, not to carve off bits to go in one direction.
And I just asked him to clarify.
Well, I've clarified it, so can we move on to the appel?
Well, whether or not if my questions haven't been answered, sir.
I think we've reached the end of what's a very long debate. The appel has been called for, and I think it's time to sit down. As I'm now speaking.
I have a question which has been
Senator
ruled
Rosa.
out of order.
Thank you. The appel has been called for. Members are invited to return to their seats. I ask the greffier to open the voting. All members have had the opportunity to cast their votes. I ask the greffier to close the voting. The proposition to refer the matter to scrutiny has been adopted. 29 votes to 13 with 1 abstention.
13 and 4, sir.
Those voting contre, Senators Routier, Osoph, McLean, Forst, Farnham and Green, the Connotab of St Peter, Deputy of Trinity, Deputies Pinnell, St Martin, Bryans, Andrew Lewis and McClinton, and Deputy Knoll abstained.
And those voting for, sir?
Those voting for, Senator Ferguson, the Connotabs of St Helier, St Clement, St Lawrence, St Mary, St Wan, St Martin, Grouville, St John and Trinity. Deputies Martin, Southern, Grouville, Hilton, Lafondre, Kevin Lewis, Tadier, St John, Higgins, Masson, Mesic, St Juan, Labby, Wickenden, Bree, Norton, MacDonald, St Mary and Truscott.
If I can just be clear on what's happened, the debate is formally suspended until the next meeting, so it will be on the order paper for the next meeting, at which point the Deputy Lafondre, Chairman of the Corporate Services Scrutiny Panel, will be asked whether he wishes to scrutinise the matter. I assume he will say yes. And the states must then agree on the return date for the proposition under standing orders. We can now move on to P138, which is the States of Jersey Law 2005 proposed amendment, States Members' Qualifications for Election, lodged by Deputy Higgins. I ask the greffier to read the proposition.
The states are asked to decide whether they are of opinion to request the Privileges and Procedures Committee to bring forward amendments to the States of Jersey Law 2005 to A, repeal Articles 4A, 7 and 8 of the States of Jersey Law 2005 and to replace them with a new article or articles to standardise the requirements relating to the qualification and disqualification for election in the States Assembly so that all members, connotabs, senators and deputies are subject to the same requirements. B, further amend Article 8 of the States of Jersey Law 2005 in order to bring the disqualification period for bankrupts into line with the Bankruptcy des Arts Jersey Law 1990.
Deputy Higgins.
Thank you, sir. And I hope all those who've just left the chamber, a mass exodus, will actually listen to what I'm going to say. I believe that this proposition is straightforward and I hope non-controversial. Now, the actual proposition itself came about by accident. I was doing some research into another proposition and came across some anomalies and inconsistencies in the States of Jersey Law 2005, which I believe it should be addressed by PPC, so that there is consistency between all classes of membership in the States Assembly and between states members and the general public. Now, over the last 8 years, the states have enacted various changes to the States of Jersey Law 2005 that have had the effect of removing virtually all the distinctions between senator, constable, and deputy,
Now all members have the same terms of office. They are elected on the same day, and they can serve in any capacity, whether it be a backbencher, assistant minister, or minister. One area, however, that has not been updated are the different legal provisions regarding who may or may not stand for election to the States of Jersey, or the grounds on which members may cease to be a member. At present, there is only one provision relating to persons wanting to stand for election as a constable, and many more relating to those who wish to stand as a senator or deputy. And while there are 10 provisions that will disqualify a senator or deputy from sitting in the Assembly, there is only one relating or applying to constables. For example, Article 7 of the States of Jersey law, a person who seeks to stand for the States Assembly as a senator or deputy must be of full age and be a British citizen who has either been ordinarily resident in Jersey for a period of at least 2 years up to and including the day of the election, or ordinarily resident in Jersey for a period of 6 months up to and including the day of the election, as well as being ordinarily resident in Jersey at any time for an additional period of, or additional periods that total at least 5 years. There are no equivalent provisions in the States of Jersey law for constables. Moving on to disqualification, under Articles 7 and 8 of the States of Jersey law, a person will be disqualified for election as, or for being a senator or deputy, if they are a paid officer in the service of the states or any administration of the states, unless they've been permitted under the employment of States of Jersey employees law. They can be disqualified if they hold any paid office or other place of profit under the Crown. They can be disqualified if they're a member of the States of Jersey police force. They can be disqualified if they are compulsory detained or subject to a guardianship order under the Mental Health Jersey law. They can be disqualified if a curator has been appointed for his or her property. They can be disqualified if an attorney has been created who will act on details of their properties. They can be disqualified if they're convicted of an offence under the Corruption Jersey law, whilst they're a public employee. They can be disqualified if within the 7 years immediately preceding the date of his or her election, or since his or her election, they've been convicted in Jersey or elsewhere of an offence in order to be imprisoned for a period of not less than 3 months without the option of a fine. They can be disqualified if they become bankrupt from being a senator or deputy, or entering into a composition arrangement with their creditors. They can be disqualified if they cease to be a British citizen, or if they cease being resident in Jersey for a period of more than 6 months. And if we can remember some time ago when Senator Sivray stayed out of the island for over 6 months, we had to have a by-election. So all these provisions actually apply to senators and deputies alone. The only disqualification provision in the States of Jersey law is for constables is Article 4A, which states that they would be disqualified for election as a constable if he or she is a paid officer in the service of the states or any administration of the states, unless they've been permitted to do so under the Employment of States of Jersey Employees Jersey Law 2005. Now, I think members will agree that these are major inconsistencies in the law, and that the law should be standardized so that all members are subject to the same provisions. Now, in the report, I stated that it will be noticed that only states members who can be disqualified from sitting in the States Assembly by virtue of becoming bankrupt or entering into a composition arrangement with their creditors are senators and deputies, and not constables. And I was going to say that surely there should be consistency on that. However, as PPC in their comments paper pointed out, there is a separate provision in the Article 24 of the Bankruptcy Disaster Jersey law. Then even constables can be stopped from being in the states for being bankrupt. But my point is, it should be in the States of Jersey law. Now, the second part of this proposition also relates to another inconsistency. And the inconsistency is between what applies to states members and what applies to ordinary members of the public. And again, it's to do with bankruptcy. The essential thing is that if a person becomes bankrupt, yes, if they pay their debts, then they are discharged from the bankruptcy. If they can't pay their debts, they are discharged under the States of Jersey law after 5 years. If you're a member of the public, then you can be discharged after 4 years. And what I'm saying here is this is an inconsistency. It places states members and people wanting to be states members at a disadvantage. So in other words, I'm asking that, again, we amend the States of Jersey law to reduce the discharge period from 5 years to the 4 years that applies to every other member of the public. Now, I want to just come on to and discuss some of the comments in the paper put forward by PPC. They mentioned that...
So, for clarification, PPC have not actually produced any comments on this proposition. We did on the one that Deputy brought last year, but not on this one, sir.
I think it might be the committee who have commented on this occasion.
Sorry, yes, sorry. It is the committee of the Constables, yes. Thank you for the correction, Constable. In the comments paper, it mentions that for complete parity, Article 7 of States of Jersey law should be included as well, which includes the term about full age and being a British citizen and the various periods of residency. What the Committee of the Constables did not notice is that the original proposition didn't include that, but this one does. I'm saying that they should be taken into account as well when PPC redrafted. Now, what the constables have been saying is that there was no need to change this law because the Royal Court exercises a supervisory jurisdiction when the constable is in office, and similar jurisdiction is exercisable by the Royal Court on representation by the Attorney General to decline to administer the oath of a person elected as constable if that person is considered to be unfit for office. Well, yes, it could be that people may be happy with that. Personally, I think that's the wrong way to go. First of all, because of the costs involved. If, for example, a constable is challenged and it has to go to the Royal Court, there are costs that may involve costs to the parish or to the individuals concerned. And then again, we're then going to come down to the argument, what makes them unfit? There is no definition of what it is, and therefore the court will have to decide whether they're unfit. My own personal belief is that it is far better to have the law stated in the States of Jersey law so we all know exactly what makes us qualified to stand or would disqualify us. And to give an example of the cost issue, Deputy Wickenden, as we know after the last election, when there was confusion over his nomination paper, that issue had to be resolved in the Royal Court. He incurred £24,000 of costs to do that. And therefore, I would argue that it is far better that we rely on statute law. The other point I would make on that is, what we would be doing if we allow the court to continue on that basis is allow the court to determine what the law is, to make the law, because they would have to say what makes a person unfit. This assembly is supposed to be making the law, and the courts can decide whether the law has been broken after we've actually made the various provisions. Now, I've already made the point again. I was just going to go back onto the bankruptcy argument, and I do believe that the law should be contained in the States of Jersey law, setting out specifically how you would be bankrupt and the times concerned. The only other point I think I will make is that in terms of law drafting time, the amendment that I'm actually putting forward would take a qualified law draftsman 20 minutes at the most to make. It is such a minor provision because quite simply, all we're asking them to do is to delete one law, delete one article and rewrite another one to incorporate all members. So that is the argument that I'm putting forward. It's quite simply, let's try and get the law consolidated, codified in one document. Thank you.
Is the proposition seconded? Does any member wish to speak on the proposition? Constable St Mary.
Thank you, sir. It was just a question for the proposer. As the Constable of St Mary, I'm required to live in St Mary. Is the for equal parity, is the deputy proposing that deputies must stand in the district in which they live?
Sorry. Constable St Clement.
Yes, thank you, sir. Just briefly, sir. This proposition was lodged just before Christmas, so I have to say that PPC nor the Constables have had a lot of time to examine it in a great amount of detail. It is similar, if not identical, to the proposition the deputy brought back in the summer and eventually withdrew. I didn't understand that one. I quite honestly didn't understand this one until the deputy explained what he was trying to do in his speech just now. And I must admit, he's got great faith in the powers of PPC looking at the proposition, because Part A, among other things, asks us to repeal Article 8. Part B asks us to amend Article 8. Now, the PPC are very good, but whether they can actually amend a repealed article, I think it might be even beyond us, sir. Now, sir, I am certainly in favour of consistency of the rules among members. That is something we've been working on for the last number of years, certainly since the Constable volunteered to remove their policing powers and so on. The consistency among how the rules applying to members will be much easier, of course, if we only had one type of member. But the more types of member we have elected on different bases, different criteria, very, very difficult to get the rules exactly the same, although I'm sure they can be improved. So obviously, if this proposition is adopted, PPC will look at it, bring back recommendations to the states, and it'll be up to the states to decide whether to approve them or not at that stage. But I do have a slight difficulty personally with Part B. It asks us to bring the disqualification period for bankrupts into line with the Bankruptcy Disaster Jersey Law 1990. But actually, there is no disqualification period in the bankruptcy law. The deputy, in his report, towards the end of his report, refers to Article 40 of the bankruptcy law, where it says at the expiration of 4 years from the date of declaration, the Viscount shall apply to the court for an order discharging the debtor. What he doesn't mention, that law also goes on to say applications can be made for a reduction or extension of that 4 year period, and the court does have discretion in that area. So I think that would be difficult to replicate that sort of that condition, which is in the bankruptcy law, into the states of Jersey law. But of course, it's something that we can look at, because I don't know who would actually apply to the court to have a period extended or reduced if someone who was a bankrupt wanted to stand for the states. I think that would be very difficult. There's a lot of merit in what the deputy has said. Clearly, we will look at it with the Committee de Constable also, and if the states approve it, and bring back appropriate regulations for the states to consider.
Does any other member wish to speak in the debates? Attorney General.
I'd like to clarify one thing, if I may, sir. In the course of his proposition, Deputy Higgins suggested that the senators and deputies were not discharged from bankruptcy for 5 years after bankruptcy, and members of the public were discharged after 4 years. Now, it's important not to conflate the 4 and 5 year periods, as they are entirely different things. Under the Desas law, the position is that the average bankruptcy for all people lasts 4 years, but that period can be extended or shortened on the application of the Viscount, a debtor or a creditor. So that's the position in relation to bankruptcies. For all of us, they normally last 4 years. What Article 8 says, which is quite different, is that at the end of a bankruptcy of a senator or a deputy, if they have not paid off their debts in the course of that bankruptcy, they will not be qualified, they'll be disqualified to stand for the next 5 years. They're quite different periods with quite different intentions. And the 5-year period has been a feature of the State Treasury law since it was passed in 1966. That's a mini way of clarification so that the 4-year and 5-year periods are understood by all members to be quite different things with different purposes.
Deputy Massel.
Yeah, very quickly, sir, and it's a question for the AG, and it is related to the point that the Constable of St Mary raised. And whilst I personally have no problem in members living and standing in their own electoral district, my understanding was there was a slight anomaly in the Constable's issue in that the Constable of St Helier didn't have to live in the parish, whereas the other constables do. And I wonder if the AG could just confirm whether that's a correct understanding of the law.
I think that is correct. I need to look at the law, but I think that is correct.
Thank you. Does any other member wish to speak in the debate? Deputy Martin.
Yes, just briefly, and I do thank Deputy Higgins for bringing this, because I think with Deputy Masson, going back to when we were looking at standing orders, and I think we did talk to the then constable who was in charge of the committee, and we pointed out the law that the constables are elected under, I think, dates back to the 1300s, and there is nothing about even residency. You don't have to be a British citizen to stand as a constable. And we thought that was quite wrong, because it does apply to the others. So I'm quite prepared to take, like my chair has said, the chairman of PPC, I think it brings up some interesting points, and why, as you say, the deputy says, sir, we are not all equal under the law. And that's the way I've always looked at simple laws. We should all be equal. And I know we're not slightly, we do slightly extra jobs. It's an extra job being a constable. But in this house, in this assembly, sir, it's the job as a states member. So under that law, I think it's sensible that we should look at this. Because it always amazed me that the constables are working on a law that is so old, it really wouldn't function today. Thank you, sir.
Does any other member wish to speak? Deputy Andrew Lewis.
Just briefly to say, sir, that I have no issue with those in public office having to meet a higher bar. I think that's a good thing. So I find it difficult to support this proposition. I see where the deputy's coming from, but a higher bar in public office can only be a good thing, particularly as some of the things we've seen happen in recent history. Thanks, sir.
Senator Orseth.
So we should not be lowering the bar. We should be bringing it up if there is any lacunas, and it's members of this assembly pass important bits of principle. If you're bankrupt, there are, of course, changes going to be made to bankruptcy arrangements. There are some changes, arrangements with creditors and a fast track and all the rest of it, where there are circumstances. But we shouldn't be lowering the bar. We should be having a common bar. And there are changes, of course, with bankruptcy that need to be made in order to deal with an arrangement of creditors. But those are issues not for today. Those are issues that are matters for later. But there's no case at all for the deputy to lower the standards for deputies, as I read this proposition.
Does any other member wish to speak? Deputy Taddy.
So it's just a general observation. I think it's interesting we've had debates about prisoners' voting rights, and in the future we'll have a vote about who is eligible to stand for public office in Jersey. Now, as a Democrat, I firmly believe that actually the say about who ends up representing them and who, by extension, can stand for election should be up to the public. It should be up to the public to decide whether they want to vote for, you could argue, somebody who is bankrupt and still bankrupt, or somebody who is, you could argue, a criminal or has a certain conviction. We know that that's another issue, perhaps not immediately being looked at. But for me, the test is not so much about financial bankruptcy, but about morally being bankrupt. It seems that we don't have any bar to say that morally bankrupt people can get elected to the State Assembly. People who are politically bankrupt not only can get elected but can lead the island and form a council of ministers at the leisure of this Assembly. But people who are financially bankrupt, who may have been made bankrupt by other people, arguably through no moral fault of their own, are then debarred from standing for election. So there are, of course, a whole hinterland of reasons and themes that come out from this debate. But I'm quite happy to support what the Deputy is proposing here, because I think we do need a level playing field, and no doubt these kind of issues are ones that need to be kept under constant review by PPC and more generally the Assembly.
Does any other member wish to speak in the debate? If not, I call on Deputy Higgins.
So if I can just ask the Attorney-General a question first before I do sum up. Could the Attorney-General, the provisions in the Bankruptcy Disaster Law whereby someone can apply to the court to extend the period of bankruptcy would only, I would assume, be where someone has shown absolute bad faith and not assisted the court and the Viscount and others in paying those debts. Is that correct?
I think in general terms that is correct, in the sense that I think generally the court and the Viscount would be keen to resolve any disaster within 4 years, and it would only be an uncooperative debtor that would generally be subject to an application to extend the period beyond 4 years.
Thank you. Very well then, to sum up, the Deputy St Mary's made a point about, Constable of St Mary's made a point about the requirement of some constables to reside in the parish. We know the Constable of St Helier doesn't have to. As far as I'm concerned, that can be resolved by PPC. They can look at the issue and decide on what it should actually be. It should be consistent. The Constable of St Clement, I acknowledge what he said about P55. When I brought P55 in 2016, it was a bit rushed, and I must admit, it didn't make sense, and that's why I withdrew it. And it was also, I didn't choose a title for it. I didn't make clear what it was about. It was P55, and it was to do with bankruptcy. Bankruptcy was just one element. I was still looking at the standards for states members. And so it gave everyone the wrong stick and confused everyone. So I apologize for that. Now, so far as some of the problems that may arise, I've tried to highlight some of the differences that are there. I've got faith in PPC that they can look at it and they can come up with a standard set of provisions that should apply to all members. And we can review that when it actually comes before the states. So far as the lowering the standards, I'm not talking about lowering the standards for states members at all. I believe states members should be subject to the same law as every other citizen in this island. And so far as the bankruptcy provision that the Attorney General has told us about, if a states member also was obstructing the court or the Viscount or trying to sort of pay off the creditors, then yes, it should be extended the period. What I'm asking PPC to do is to look at the law in the States of Jersey law and the Bankruptcy Disaster Law and standardize it so that states members and members of the public are treated in exactly the same way. So it can be that, 4 years is in the Bankruptcy Disaster Law unless an application is made to the court. That provision could quite easily be put into the law for states members as well. What I hope members will see is we've all accepted that there are, sorry, I just make one other point too. I fully agree with the Constable of St Clement. Really, there is no need to have 3 classes of member. There is nothing to distinguish between the 3 of them except for the name. And if PPC wanted to put forward that, I would support it. But we have accepted in this House, since the referendum, constables were looked on as being a member of the States of Jersey as ex officio members. They weren't actually elected to the States, or it wasn't perceived. The constables are in the States. We all accept it. They do a valuable role. Deputies and senators do a valuable role as well. What I'm saying is we should all be treated equally. Same. Should be, unless there's an exceptionally good argument, which I can't think of, maybe PPC, when they bring it back, will. But I hope that members will agree that there should be one set of standards for all. And I ask for the appel.
So I wonder if I could ask the Attorney General, sir, just to clarify something the Deputy said there. I thought that under the disaster law, currently, states members and members of the public were treated equally under that law currently, sir.
Attorney General?
Yes, that's quite right. All members of anyone in Jersey is treated the same for the purpose of the disaster law. Normally, a disaster will last 4 years. And what the States of Jersey law says, which is quite different, is that a person is disqualified from being a senator or a deputy for a period of an additional 5 years after the end of the disaster if they failed to pay their debts in full. In relation to constables, they are disqualified for the period of the disaster, and of course, they of course are subject to a separate supervisory obligation to the Royal Court, because of course they have fiduciary duties towards their parishioners, and that would be considered on a case-by-case basis in terms of their position and their finances after any disaster.
Very quickly. Deputy.
Yes, if I can just thank the Attorney General for that. I think the thing is that, again, it's showing this inconsistency between constables and other members, which perhaps PPC could look at. What I'm going to ask for the appel, I'm going to ask it in two parts, Part A and Part B.
Appel has been called for on part.
I wonder if the Deputy would agree to take the two paragraphs separately, sir?
Separately,
He's just asked to do that, I think. The appel has been called for on the paragraph A of the proposition. Ask members to return to their seats. And if they're all here, I ask the greffier to open the voting. If all members have had the opportunity to cast their votes, I ask the greffier to close the voting. Paragraph A has been adopted, 26 votes to 14.
Those voting contre, the connotables of St. Lawrence, St. Mary, Greville and St. John, deputies Knowles, St. John, Pinnell, St. Martin, Bryans, Andrew Lewis, St. Juan, Wickenden, Norton and Truscott.
We now move on to the appel on paragraph B. I ask the greffier to open the voting. If all members have had the opportunity to cast their votes, I ask the greffier to close the voting. Paragraph B has been rejected, 29 votes to 14.
We have the 14 on this one.
Those voting for, Senators Farnham and Ferguson, the Conotable of St. Helier, deputies Martin Southern, Greville, Kevin Lewis, Tadia Higgins, Mesick, Labby, Bree, St. Mary and McClinton.
So that concludes the public business. It just remains to ask the Conotable of St. Clement to tell us about the arrangements for public business next time.
Yes, the proposition for the arrangement of public business is as per the consolidated order paper, except I would say this, and I did ask the greffier to send an email round to members. For the next sitting on 31st of January, we have a terrific amount of business. We have the vote of no confidence in the State's Employment Board, and we have the debate on the composition and election of the State's Assembly proposed by Deputy Lewis. There's already one amendment being lodged. I understand there are some further amendments or at least one other amendment to come. So that is going to take a tremendous amount of time. And I would like to suggest, sir, that in view of that, the State sit on Monday the 30th, 2:45 in the afternoon for questions and any statements, and also be prepared to sit on the Friday of that week, because I suspect that this could be a significantly long debate, sir. I'll make that proposition.
Deputy Southern.
So, seek a direction from you, sir. At the next meeting, I wish to ask further questions on the Innovation Fund, and I wish to know who to direct that to, because as far as I know, the Assistant Minister responsible has not yet resigned.
I can assist. I can assist with that one, and the answer is the Chief Minister. Secondly, if the State agrees to sit on the Monday, that will have, I believe, a knock-on effect on the deadlines for written and oral questions. I'm looking at the nodding heads of my colleagues, which we will be able to provide further guidance on. The deadline for written questions will be tomorrow if we sit on Monday the 30th of January.
So I just wonder if the chairman of PPC will make his proposals in two parts for the Monday and the Friday, because I think some members will already be committed, and I wonder if we could just proceed in that manner.
Does any other member wish to speak on this matter?
Yes, sir.
Senator Rutty.
It has been practice in the past when additional sittings have been arranged at short notice that members who have had prior commitments have been excused being in the Assembly. I know we have a duty to be here, but some people may have specific things which they're unable to rearrange, and if they could be looked upon favourably. I'm not saying that I'm out the island or anything, but I'm just saying an observation that sometimes some members have found it difficult to rearrange things, so they might be excused.
Chief Minister.
So during question time earlier this week, it was suggested that members would like to understand what proposals might be being brought forward for machinery of government, and I suggested that I'd have a conversation with Deputy Andrew Lewis about moving his electoral reform proposition. We've not yet had that conversation, albeit we've had a short conversation. I intend to do that, sir, and ask him if he would consider deferring it until a later sitting. So members just need to be mindful of that as well, sir.
I think, so before, I think that's putting the Assembly in quite a difficult position, because the Assembly has to decide now whether it wishes to sit, in particular on Monday the 30th, and obviously there'd be no need to do that, I imagine, if that particular proposition was moved.
Perhaps I could assist, sir.
Deputy Lewis.
As far as I'm concerned, sir, there is a significant amount of information out already of reviews and reports that have been done over many years about the machinery of government. I would urge members to read that before the debate on the 31st. I think that would inform them quite well, although I'm more than happy and intend to have a conversation with the Chief Minister on the matter of P133 anyway.
Deputy Tadyer, do you still...
In other words, I'm not prepared to defer it unless the Assembly was to vote that way, sir.
Deputy Tadyer, did you still wish to speak?
Yes, sir. I was going to ask whether it's possible for the head of the government to make his position clear on the reform proposals, because I think that's a matter of not just public interest, but specifically for the Assembly, to know what the Chief and the Council of Ministers think of the reform proposals, and if they were intending to support any.
I'm not sure that's a matter for now, otherwise we may well sit on for quite a
I don't need a
period.
decision, sir, but maybe the Minister could ponder that and circulate information.
Senator Orseth.
Thank you, sir. I'm the member with an amendment, sir. I think the reality is we've just had a debate this morning about whether or not things should be scrutinised, and good information before members. We may be faced with, I understand it, last-minute amendments, which, whilst there has been a lot of work, the implications of this are at the very fount of our democracy. The implications of this are even bigger, if I may say, than the matters that we were discussing earlier. And I just wish to say so. I, unfortunately, have a long-standing personal engagement on the 14th of February, where I am out of the island. I can be in the island later than that in the week, if that's what members would wish to do. But I have an amendment in, and I have a long-standing personal matter which I cannot. It is actually state's business, but I cannot, which is a result of state's business obligations. I cannot do it on the 14th. So it is a matter, obviously, for members. But I would have thought that in the, from what I hear, is the further amendments before members, if there's been chaos this morning understanding things and having proper information, then we're going to be at serious risk for that. So I would have suggested respectfully that, in fact, there is, and I also, sir, as a member of PPC, have received your advice as in your position as greffier in relation to needing to deal with matters within a year. And I think the PPC, sir, has discussed the matter of the absolute clarity needing to be, you need to deal with matters. I think your advice has been a year, and that's a general principle advice. Legislation may possibly be able to come later, but the principles need to be absolutely clear. But I would have thought that a 2-week delay knowing that there are amendments down and further amendments being drafted. This is the most important thing that the Assembly will discuss.
I don't want to interrupt, but I think I've got the gist.
Right,
and,
so.
and I think we are on the arrangement of public business, not an opportunity to have a speech.
So,
can I finish?
Please, sir. It's
up to Deputy Lewis what he wants to do with his proposition, and I think he's made it clear this morning that he doesn't intend to move it. The Assembly, I think, has to proceed on that basis, that proposition will be there, and therefore the arrangement of business that's down here on the sheet for the 31st of January is the one that will reach us. And that's the basis on which the Constable has made his comments. Senator, did you want to...
Point of order, sir, if I may. It is up to the Deputy to propose, but it is for the Assembly to decide.
That's very true, but there isn't a proposition to actually
Well, I
move
was
it at
going
the
to make
moment.
it, sir. If I was just trying to take the mood of the Assembly as to whether or not a proposition should be made in order to deal with it in the sitting of the 14th, which is 2 weeks later. It can't be done later than that, clearly. But I will make arrangements. I'll make arrangements that I am back for the 15th.
So
I guess it could be probably the second item of business, sir. I'm trying to be reasonable, sir, as always, and to make sure, clearly, we've had this morning information chaos, and I just want to make sure that we don't have information chaos, sir.
So this is absolutely bizarre. The proposition that I have made is as per the consolidated order paper, which includes on the 31st of January Deputy Lewis's of St Helier's proposition on reform of the states and any subsequent amendments. No one has proposed that it should be on February the 14th when Senator Roseff is away. If someone wishes to do that, of course they're perfectly entitled to do so, I believe, sir. But let's get real. The proposition is quite clear. Items on the consolidated order paper for the 31st of what I am proposing, and I'm also proposing we meet at 2:45, and it's 2:45 because there is a schools assembly beforehand on Monday the 30th, and the state should be prepared to continue after the Thursday, and I have suggested probably the Friday. But let's not confuse matters. The proposition is a simple one, and if someone wants to propose it, it's a different date, well, that's fine, but no one has done that so far.
Deputy Titan.
No, I think the Constable's made the point that we were all thinking.
Deputy Andrew Lewis.
So we have put this off for 16 years. I think members hopefully will accept that the order paper is the order paper. I've lodged it in good time, sir, and I'm not proposing to delay it. And if nobody else is, I would like to propose that we accept the PPC chairman's recommendation.
I think that's the key bit. Sorry, Constable, I'll come to you in a second. As I understand it, the only proposition on the table at the moment is to sit additionally on the Monday afternoon and on the Friday, which we may take separately. That's the only actual proposition.
I do have a question. Now that we know Senator Roseff's away on the 14th of February, are there any other propositions we want to move to that date?
No, I regret calling you for that. Constable St Mary.
Thank you, sir. Notwithstanding what's just been said, I've talked a lot about clarity and certainty today, and I always do. We have a procedure in standing orders for what we do with business that's unfinished. And I understand the merits of starting early. We do it for the set pieces, the budget, etc. But are we really saying that we're going to chop and change on uncertainty? We don't know how long any particular debate would happen. We don't know whether things will happen in the interim that will change people's minds about things. Surely the thing to do is to go by our standing orders, sir, and start as normal, follow through, and then move the business to the next sitting as we've already agreed to do, sir.
Any other member wish to speak? I think you've already spoken.
I want to sir,
that's not an invitation to speak again.
Assembly.
Is this a point of order or a point of clarification?
I want to make a proposition, sir.
Okay.
Because it's fair, only right to test the mood of the Assembly. That's right, isn't it?
Absolutely.
Right, fine. So, sir, I move that the proposition for Deputy Lewis, in view of the fact that there is going to be further propositions lodged which will not have proper time for reports, 16 years or otherwise, they need to be properly analysed, etc. If it's the mood of the Assembly not to take it, I will be here if it was to be put on the order paper for the 14th. I will be here for the 15th, etc. That can be organised quite clearly. I won't be prejudiced in any way. I think that the mood of the Assembly should be tested, sir. so that they have the option. There is time. The most important issue, we've had a debate this morning about detail, 16 years, but nevertheless, we've been talking about the hospital for 16 years, but we're still unclear. I move the proposal to move it to the bottom of the order paper, or just the penultimate after perhaps discussions with whoever is there, and also to receive and to support the proposal of the Constable of St Mary, that the proposal, my two-part proposal is we meet on Tuesday morning and that this matter is dealt with on the sitting of the 14th.
So which day a month are we referring to here? Is this the sitting of the 14th of February?
No, 14th of February. 14th of February stands, as usual, on a Tuesday. Matters are
So
dealt
it's the
with.
end of the list on the 14th of February that you'd like this
or in consultation with members further up the list, but on the sitting of the 14th.
On the sitting of the 14th. Is that proposition seconded?
Yes, sir.
Not me. So can I?
Deputy Mesnick.
Thank you, sir. There is a fundamental flaw in the argument that Senator Joseph is making when he says we should delay P133 so that we've got more time to consider the amendments, which is that if P133 is delayed, so is the deadline for amendments, so we can still get amendments coming in a week before it's delayed. There is no logic behind his argument, and I would ask States members to reject this. As Deputy Lewis said, we have put off having this debate, this real debate, for 16 years. The public are fed up with it and want us to get on with it, so let's just do it. Members have had since before Christmas to know that this is on the agenda and lodge amendments if they want. There's still time to do so, so let them do it and we can have that debate.
Deputy Martin.
Yes, just briefly, sir. I'm very concerned, and it follows on from what the Constable of St Mary has said, and now this proposition. If we move this debate to the 14th of February and we do not finish, we don't sit again to the 14th of March, and that's too long. We cannot be in the middle of a debate. I absolutely reject this. We need to get on with this P133, and I support the Constable of St Clement. Thank you.
Just to clarify, the proposition is to move it to the sitting on the 14th of February. What would then happen if, at the end of that last continuation day, the business wasn't concluded? Would be decided at the time. This isn't a... Okay. Any other member wish to speak? In that case, I call on the Senator to sum up.
Thank you, sir. I'm grateful for members' observations. The matters, I'm looking forward to the matters down for the 14th of February would mean that we would be able to deal with on the next sitting, the SEB matters. We would not have to sit on the Monday afternoon. We can deal with all of these massively important issues, and we can start on the 14th of February and deal with the most important thing, which is the foundation of our democracy. And we can conclude that, and certainly I will make myself available to be here. And I would suggest the members that would then be putting propositions wouldn't seek to try and put late amendments. And I also remind members that the Deputy Lewis put his proposition. It is, as I've said in my own remarks and in my own amendment, it was my proposition anyway. I didn't know anything about it, but it has been put forward. I've amended it in the proper way. There are other members that I know that are going to put further amendments. We can deal with good foundation of good information presented more properly on the sitting of the 14th of February and avoid the kind of chaos that we've had this morning. And on that argument, I ask members to agree that it is moved to the 14th of February so that we can have proper information and deal with this most important issue in proper time. I move my proposition. Ask for the appel, please, sir.
So I do have a point of order.
I hope it is, Deputy.
I think it's a point of order. We need to know at which point on the order paper for the 14th, I know it's academic, presumably, but we need to know at which point it would come, because the Senator's told us he's not here on the 14th when it will be debated, and he's got an amendment which would be put in. Is he going to be here on the 14th to move his amendment to the proposition that afternoon?
Well, I think...
I always put my public duties first. If that's the will of the Assembly, I will be here.
I think the proposition will be put at the end of the order paper. There's obviously scope for further discussion further down the line as to exactly where it goes, and the Assembly always has the discretion to take things earlier if it wishes to during the session. I think that's the position we're in, and the appel has been called for. Members are all here, I suspect, so I ask the greffier to open the voting. If all members have had the opportunity to cast their votes, I ask the greffier to close the voting. The proposition has been rejected for 31 votes contra, 8 votes per, 2 abstentions.
Those voting for: Senator Routier, Ossoff and Gorst, Deputy of Greville, Deputy of Trinity, Wickenden, Norton and St Mary, and the Conotabs of St Peter and St Mary abstained.
So we return to the arrangement on the 31st of January sit-in. Does any member wish to speak on that subject? Deputy Sutton.
Just briefly, sir, the amendment by the Constable of St Mary.
Point of order, sir. I haven't made an amendment. I was
I
just
didn't think
explaining
you-
why I was going to not be supporting the.
Chair, made an amendment. Okay.
I
A
didn't think you
suggestion
had.
by the Constable of St Mary that we should carry on as normal, which is not to meet on the Monday but to meet on the Tuesday as normal, I'm fully in support of.
Any other member wish to speak? I ask the Constable of St Clement to wind up.
I'm already well wound up, sir. I'm not sure if we need to take this proposition in three parts. Firstly, that we take the items on the order paper. Secondly, that we meet on the Monday afternoon. And thirdly, that we continue on the Friday if necessary. It seems to me we need to make those three separate decisions, sir. So I would firstly propose the items on the consolidated order paper be taken on the at the next sitting, sir.
Sorry,
Thank
to
you.
test. So can I just check that P117, my TV licences, has been moved to the 14th? I think that's what the Gref and I agreed. And I'd like it to be taken as the first item, but I know that's not necessarily, that's in the hands of the Assembly.
Well, we can confirm it's been moved to the 14th of February. I think we'll leave it at that for now. Those members who are in favour of the items on the order paper being taken on the 31st of January kindly show. Those not in favour, I think that's been agreed.
Right, the second part of the proposition, sir, is that the state should sit on the 30th of January at 2:45 in the afternoon for the purposes of taking questions and any statements that may be made, sir.
The appell's been called for. Members invited.
It's a proposition we're entitled to speak to.
No, it's not. The proposition has been debated throughout, and this is the putting of the questions at the end. The appell's been called for. Members are invited to return to their seats.
So are you saying that we can't speak on this bit of the proposition?
We've had a debate on the arrangement of business for the 31st of January, and the three components of that are the items which are on the order paper, number one, whether to sit on the Monday, number two, whether to sit on the Friday, number three. That's been the subject of the debate, subject to the additional discussion about the 14th of February. That debate's now finished. Conotab is now putting the questions one by one to the vote. And we're on the second question. The appell's been called for, and I ask the greffier to open the voting. If all members have had the opportunity to cast their votes, I ask the greffier to close the voting. And the Monday meeting proposition has been agreed to, 28 votes to 11. Conotab, you wish to proceed with the Friday?
Yes, please ask for the appel, sir.
Appell's been called for. This is whether to extend into Friday if necessary. I ask the greffier to open the voting. If all members have had the opportunity to cast their votes, I ask the greffier to close the voting. And that proposition has also been adopted, 29 votes to 9 with 1 abstention. I'm pleased to say that concludes the business for this sitting, and the States is adjourned until Monday the 30th of January at 2:45 p.m.